Well, good afternoon, everyone. I'm Tim Blotz from Fox 9 in Minneapolis. Welcome to our streaming coverage of Day 13 now of the federal civil rights trial for the three former Minneapolis police officers who assisted in the arrest of George Floyd. Now, these three officers are Tou Thao, J. Alexander King, and Thomas Lane. They are all accused of depriving George Floyd of his constitutional rights on May 25th of 2020, and that's when he was placed under arrest for trying to pass a counterfeit bill at a convenience store at 38th and Chicago here in Minneapolis. We all know that locally as Cup Foods. Now, Derek Chauvin was the fourth officer on the scene that day. He's already pleaded guilty in this particular federal civil rights case. But he's also now in prison, too, for the death of George Floyd in that case that happened last year. Rob Olson has been in federal court in St. Paul and joins us now for the testimony that happened this morning. Rob, use of force expert on the staff here today, on the stand, I should say, Timothy Longo, and he's for the prosecution here. Walk us through some of what he had to say.
Yeah, and the prosecution still expects to rest today, so whether he's the final witness or there's another one, we shall see. But again, we're nearing the end of the prosecution side of the case. Timothy Longo is from the University of Virginia. He is essentially the police chief for the university there, as well as an adjunct professor in use of force in the law school. Prior to that, he was a chief in Charlottesville, and then before that in the Baltimore Police Department. But he testified about use of force, about intervening, about that duty, about providing medical aid. Some of these things have been covered before by previous witnesses. This is the first, though, use of force expert witness, you know, one of the people that you bring in from another part of the country, another department, to testify as your objective witness, in this case, on the use of force and the other duties here. So he talked about, you know, basically when does the use of force, when is it required? When does that use of force necessarily stop or diminish? He said, you know, he's asked, what if a person stops resisting? And he says, I think the use of force stops. So they're trying to ask specific questions here about George Floyd's actions and behavior, and then certainly his medical condition, saying that a use of force is something that is constantly reassessed based on the threat, that when somebody is handcuffed, the threat is greatly diminished. And then talked again to his, I don't know how many witnesses have talked about the side recovery position, that you do not keep somebody prone face down because it inhibits their breathing. He again also testified to that is something that you do as soon as you can, put them in the side or put them on their into a sitting or on their feet. Continued to be asked questions about specific to the officers, about the duty to intervene and about providing medical aid. And he said these officers in each of these cases acted inconsistently to what the known best practices, commonly accepted practices and policies of policing are, including those of the Minneapolis Police Department.
Rob, kind of interesting there because you hit on a couple of things about how this is not the first testimony of its kind to come up now about the duty to intervene. I mean, last week we had MPD homicide investigator Richard Zimmerman, along with the officer's trainer, Nicole McKenzie, all testify that these officers had a duty to intervene. I'm not in the courtroom, but I'm curious your observation. At what point is the judge saying that, okay, we've heard these questions before, please don't be so repetitive, or is he allowing them to proceed?
Well, once again, the judge is responding to objections about repetitive questioning, and he's very testily said, you know, sustained those, saying, yes, we've gone over this area several times. That's occurred throughout, especially from prosecutors who tend to have very lengthy direct questionings that will often then come back to very similar questions that they've asked before, maybe slightly different, but essentially getting at the same thing. And then that's when the judge says, yes, I mean, this has been asked and answered. Now, in this case, what this is doing, and you see this very commonly in trials like this, where you have your local experts, as you mentioned, the folks from the Minneapolis Police Department, our medical examiner from Hennepin County, but you bring in, they've had 2 medical experts from out of state. One was an expert in pulmonary issues, and the other one was on toxicology. Now here's a use of force expert. So they bring these in to have somebody who is looking at this from outside, the bubble of what we're in.
The sphere of
outside
influence,
this
so to
department.
speak. Yeah.
Yeah, and to provide basically their opinions, which may be the same, but it kind of gives it that objective level of somebody who wasn't here. Now, in cross-exam by Tom Plunkett, who represents J. Alexander King, one of the first things he brought up was that he had been sent evidence, reports, videos, etc., not long after this incident took place in late May of 2020, is a potential defense witness for Hennepin County prosecutors. So he reviewed all of this. He was ultimately not retained as an expert witness for them, but he'd reviewed all this and provided a list of questions back that these officers should be asked. And so he didn't see that as being in any way conflicting here, but defense attorney Plunkett trying to raise this issue about potentially his objectivity for the jury. I mean, it doesn't really go anywhere, but it throws those kind of doubts and questions out there for the jury to think about.
And Rob, I found it kind of interesting that Tom Plunkett, the attorney here for, I believe, J. Alexander King.
For King.
Yep. Yeah, exactly. Also, in his questioning, tried to use this expert witness for the prosecution as perhaps a little bit of his own witness too, in talking about the training materials for MPD and how they may not have been sufficient, especially on some of these issues.
Yeah, and that's what the defense attorneys mentioned in the outset in opening statements, that they intended essentially to put the Minneapolis Police Department's training on trial here, to say that these officers and suggesting, that these officers were undertrained about a duty to intervene, certainly, and that a paramilitary culture of the police department may have kept certainly officers Lane and King in particular intimidated from doing anything other than what Derek Chauvin told them to do. So certainly in this cross-examination from defense attorney Plunkett, immediately kind of went after these training PowerPoint procedures, the duty to intervene, which is just only briefly mentioned in the PowerPoint training. Now, this use of force expert who went over all this training and testified that it is contained in their training and their policy, but when Plunkett says, well, you don't know how much time they spent on it. You don't know if they even followed this lesson plan. And he said, no, I didn't sit in on the class. I have to assume that they did. It's in their packet of information. It's in their plan. But basically trying to put doubt in there about, well, that doesn't necessarily mean this training was given the attention that you may think it does because it's in this PowerPoint or in this policy manual.
Robin, I want to take a half a step backwards because you just talked about the leadership and or power dynamics that were on the scene that day, because Derek Chauvin was the FTO, the field training officer. At least 2 of these officers, King and Lang, were basically rookies just days on their job. And so you've got this interesting dynamic that's taking place there in the field that day, where would they disobey a superior officer, and especially their training officer who has the power over them to recommend whether they become full-fledged officers or not. But it sounds as if Professor Longo on the stand today said that these officers still had the duty to intervene and reject what Derek Chauvin was telling them to do.
Yeah, and he had pointed that out in his direct questioning today, because he was asked about this, because the prosecutors know that this is another defense strategy or tactic or point they're trying to make, is that because of that power structure and dynamic, that these two officers in particular would have been very intimidated by Derek Chauvin, who was their field training officer for both of them. Now, they were full-fledged officers at this point, but only a couple of days into that classification, I guess, a couple of days into their actual street duty as full-fledged officers. So they didn't have that dynamic anymore, technically or officially. But the defense trying to say that, well, this is still a very intimidating presence for them, and so, that they would be following that kind of chain of command, even though they're all equal officers at this point. Longo is saying that, pointing out that that shouldn't matter, that doesn't change anything about your duty to intervene when you see someone else using force that you deem to be unnecessary and dangerous at this point, that a knee on the neck when somebody goes unresponsive is no longer necessary and it's dangerous, and they had that duty. And so the prosecutor very much trying to preemptively attack that defense tactic about that. And then he also mentioned, too, that even though, again, he was their field training officer, he wasn't anymore. And so that shouldn't be a part of it. But that is something, again, defense attorneys are very clearly trying to make a case for the jury that power dynamic was there.
Rob, you indicated that we could wrap up the prosecution in this case today. Give me your sense of how the judge is trying to proceed on this. Is it likely that the defense could start today, or will they take a break as soon as the last witness is done and have the defense start tomorrow morning?
Well, that all depends on when the last witness is done.
It does, doesn't it? Yeah.
If it's anywhere close to the 4:30 when he tries to, cut things off for the day, then you'd be done. But if it's any time before that, you're going to move right on. He wants to keep this thing moving along, and so for the defense, that means just calling whichever one of the three attorneys here goes first with their witnesses, calling their first witness. There's no other opening statement to make. It's like, get on with your witness now. And so I would think that, again, provided how long this cross-exam takes here with Mr. Longo, if there's any other witness lined up for the prosecution before they rest, I mean, that all plays a factor here. But the judge will keep this moving as quickly as possible. One other thing, Tim, before we go to that, I wanted to point out in this cross-examination that Tom Plunkett just brought up, again, who represents King. Thomas Lane, he pointed out, is not charged with the failure to intervene with the use of force, but King is. And he asked Mr. Longo, Thomas Lane asked twice to Derek Chauvin, should we roll him over? And he was rebuffed. He was denied. My client, Mr. King, would have been right there and would have heard that, right? And he said, I'm guessing that he would, or I'm sure that he would. I can't remember his exact wording. And he said, well, then, in his mind, that would be sort of an asked and answered. Why would he ask the same thing? Mr. Longo says, well, can't answer that. He doesn't know, he wasn't there. But again, that's another chance that with these witnesses, that you ask these questions to raise that doubt in the juror's mind that, J. Alexander King didn't ask, should we turn him on his side? His partner, Thomas Lane, did, who was a couple feet away, and he would have heard that. That's important for the jury to think about.
So why
that,
re-ask the question is essentially what he's saying. Yeah. Right.
Yeah, if Derek Chauvin says, no, he's staying where we got him, why would J. Alexander King ask the same thing? A valid question to put in the minds of jurors in this, even though no one can answer that.
Right. All right. Rob Olson coming to us from Federal Courthouse in St. Paul. Rob, thanks so much. We'll let you get a break now for your own lunch. Court will reconvene here at 2 o'clock this afternoon. We will have a wrap-up tonight on Fox 9 News. On behalf of all of us here at Fox 9, I'm Tim Blotz. Have a great afternoon. We'll see you on the news at 5 o'clock.